appoint the arbitrators, and also the lack of an approved mechanism has been used to attack the legitimacy and accountability of investor-state arbitrations. Two solutions are generally proposed: amicable participation and information disclosure, and I'm going to focus on information disclosure. The Bywater Tanzania case is perhaps the only arbitration award that has dealt with in detail the question of information disclosure. In this case, the respondent, Tanzania, had unilaterally disclosed documents to the public, and Bywater had sought an order to prevent the continuing disclosure of these documents, and they wanted at the very least that both parties should make a joint decision as to which documents should be disclosed or not. The tribunal in this case acknowledged the fact that parties are free to conclude any confidential agreements, any confidential rules they wish to enter into. But the tribunal weighs to competing interests, the need for transparency on the one hand and the need to protect the procedural integrity of the arbitration. The uniqueness of the award was how the tribunal treated different documents differently and came to different conclusions regarding the public availability or confidentiality of these documents, and it also differentiated between the release of documents while proceedings are pending and after the completion of the proceedings. Despite this slight development as far as information disclosure is concerned in BIT arbitration, there are still deficits in the availability of information. In some instances, the public has no way of knowing any of the following: whether a case of arbitration exists, what the allegations of wrongdoing are, what legal issues are at stake, the legal arguments that are being placed, and in some instances, what the final award is and whether it affects public interest or not. In February, a working group of UNCITRAL met in New York to discuss what new transparency rules should be introduced into investor-state arbitration. Divergent opinion was expressed and they could not come to any conclusion. The one thing they were unanimous about was that whatever transparency rules are introduced, it has to be subject to any confidentiality clauses that parties agree to. So if you've got this sort of internal resistance from the investment community with regard to transparency, how then can you address the problem that the NGOs in South Africa faced in the Periforestry case? After this incident, there was an amendment to the Companies Act in South Africa, and it's developed a broad range of transparency and accountability rules that govern juristic persons in the country. And juristic persons, in terms of the Act, extends to foreign companies operating in South Africa. And the Act is clear that the rights of access to information set out in the Act are in addition to and not a substitution for any rights in the Constitution. And this supports a point that I try to make in the paper, that while you can have a broad right of access to information, it will probably be most effective when you have a regulatory framework that supports the adoption of the effectiveness of these rights. Take the example of Kenya, where also you have a similar constitutional provision, but it does not prescribe it that legislation must be enacted to give effect to these rights, which pretty much means that transparency advocates in the country, whether they're trying to seek information from government or from private entities, would have to directly rely on the constitutional provision. And this will create a huge dilemma for them because there's an absence of criteria, which Henry mentions, deals with quite succinctly in his presentation, in his paper, and that creates a potential that weakens the effectiveness of these rights. And the point I try to make in this paper is that rather than focus on adopting a broad right or legislative framework for access to information, rather focus on targeted transparency, rather mobilize for sector-specific transparency frameworks. And an example to illustrate this is the Political Parties Act in Kenya, where the Act allows individuals to obtain information relating to party funding. Whereas in the case of South Africa, no such legislation exists, and in fact, a public interest organization in South Africa attempted to obtain, relying on the constitutional provision, to obtain information relating to party funding. And this request was denied on the basis that political parties were not public bodies, and when they sought to obtain information on the basis that political parties are private bodies, the court held that there was no sufficient connection between the rights they were seeking to protect and the information they were trying to obtain. So in conclusion, I make the point that given the fact that the adoption of freedom of information laws and the continent has not been successful, it might be high time transparency advocates looked at the idea of using sector-specific transparency objectives to drive the campaign for transparency on the continent. Thank you.
Well, thank you. Again, sorry you had to rush.